What if I told you that every step you've ever taken, every trip to the grocery store, to the gym, your late night runs to the Taco Bell, could all be tracked on your cell phone? And days, months, or even years later, the police could access that data without getting a warrant. That is exactly what was at stake in Carpenter versus United States. The case that made sure the Supreme Court answers a simple question: whether the Fourth Amendment protects your data, namely the geographical location data, or do you give up your privacy rights the second you turn on your cell phone? Today, we're going to discuss Carpenter versus United States, a string of robberies, 127 days worth of phone data, and one man's records, his geographical location records, and how they changed the way we look at the Fourth Amendment and the Constitution. I welcome you to the 7th part in my 10-part series where I discuss 10 of the most important Supreme Court decisions and the myths surrounding them. Now, we've discussed many different concepts so far. One of those, of course, was Katz, the Supreme Court case that dealt with the private conversations over electronic communication devices are protected under the Fourth Amendment. And I've mentioned in that video that, of course, since Katz, the Supreme Court made many rulings about new technologies. Of course, half a century later, if not more, the technology has significantly changed. So I picked Carpenter versus United States because I think it brings us to the digital age. And so today we're discussing Carpenter versus United States and how we look at the historical location data from your cell phone. I welcome you to the Lost Dash channel. If you're new here, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And if you want to support this channel, consider going to lostdash.com/merch or shop.lostdash.com and check out these Do Not Arrest This Person t-shirts, stickers, hats, pins, and other items. And because you're watching this series, if you type in 10 cases as the promo code, you will receive 10% off. So let's move on to part 7 in my 10-part series, and we're discussing Carpenter versus United States.
Quick message from Lost Dash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lost Dash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lost Dash YouTube page. That's LAWSTACHE.
Now that you've learned that you're being tracked by your phone, and before you throw it in the trash bin, please finish this video, so at least I get the credit. Today, we're discussing your privacy rights in the digital age, Carpenter versus United States. A few years ago, I've discussed this case in great detail, and I think I've done a really good job. So today, we're gonna revisit that discussion. I'm gonna turn it on, we're gonna watch it together, and then we're gonna move on to some of the biggest misconceptions or misunderstanding surrounding Carpenter versus United States. So even though I'm replaying parts of that previous video, we're gonna finish off with the usual misconceptions like we've done in other parts in this 10-part series. So let's move on and look at the discussion of Carpenter versus United States. There are 396 million cell phone accounts in this country. Think about it. That's more accounts than we have people living in the United States. Every single person, or just about, has a cell phone. Now, these cell phones connect to cell towers. Cell towers are actual towers, but sometimes they're little antennas on top of buildings. When we're talking about big cities, cell phone companies have a lot of these towers. And if you think about it, your cell phone connects to cell tower multiple times a minute. Even if you're not using it, it is trying to search for the best reception that your phone can get from your provider. So here's what we can gather from the information. We can pretty much figure out exactly where you've been over the past years. Sometimes these companies hold these records for up to 5 years. So we can really tell which 7-Eleven you visited, what bank you go to, with pretty good precision. Here's what happens in the Supreme Court case Carpenter versus United States. In 2011, there were a number of robberies of Radio Shacks and T-Mobile stores. Now at this point you might have to Google what these companies do, but once you figure it out, you'll see the irony given the nature of this case. Now one of the suspects tells the police that there are other people involved in the robberies. He provides names and cell phone numbers. One of those people is Mr. Carpenter. So here's what the police does next. They get a court order, basically a subpoena, which all they have to show is reasonable grounds to get information. And they get information from Mr. Carpenter's cell phone provider. They get 127 days worth of information, or nearly 13,000 points or connections to cell phone towers that Mr. Carpenter's cell phone connected to. That's a lot of points. And as the prosecutor said in the court, that we can pretty much tell exactly where Mr. Carpenter had been. And in fact, every time he has connected to a cell tower close by to the crime, to the robbery. Mr. Carpenter argues that the government needed to have probable cause and get a warrant before they could get this information, while the government argues the opposite. They say because Mr. Carpenter shared the information with a third party, namely the cell phone provider, he does not have a reasonable expectation of privacy in the data. And so this is not even a search under the Fourth Amendment. So let's quickly examine the history of the Fourth Amendment. The Fourth Amendment protects you against unreasonable searches and seizures, and generally speaking, the police need to get a warrant before they search you. Now there's two different ways of looking at the Fourth Amendment. For example, in Jones, we know that the police need to get a warrant before they can put a GPS device underneath your car and track your movement. Now we know that because the Supreme Court said that the Fourth Amendment always applies the rule of trespass. I have a video on Jones, and I will link it here above, and I encourage you to watch it. Another way of looking at the Fourth Amendment is, for example, in the case Katz, we know that the police need to get a warrant in order to listen to your phone calls because you have a reasonable expectation of privacy. That's a different way of looking at the Fourth Amendment. Now, the courts always have to balance the privacy interests of the individual versus the interests of the government in getting the information. And let's think about it. We know that the modern world moves forward, and there's newer and newer technologies coming out every day. And the courts have been trying to go along with the technology. From the case Kylo, we know that the government needs to get a warrant before they can use thermal imaging to look through your walls. We also know from the case Riley that's because cell phones have so much information, medical information, banking information, and so on, that the government generally needs to get a warrant before they can search your cell phone. So how do these cases apply in this situation? The Supreme Court tells us that just because a third party is holding the data points, that fact alone does not diminish or overcome your Fourth Amendment claim. And it really doesn't matter whether the government is using its own technological powers, like they did in Jones when they installed the GPS device, or if they're harvesting third parties' technological advances, such as in this case. At the end of the day, the Supreme Court tells us that the user does have a Fourth Amendment right because he has a reasonable expectation of privacy in his physical movement and the data points that tell the government where he's been. The Supreme Court gives many reasons why we have reasonable expectation of privacy in those data points.
The first is, how can you say that your privacy is invaded by a record of where you've been in public? We think the answer is that there is a difference between where you are at any particular moment in public and a record of where you've been every day, every moment over several years. Now, in the past, the government could track you at most for a few days with the great expenditure of resources. But with CSLI, our cell phones become like ankle monitors, enabling near-perfect surveillance at nearly no expense. And the government does not have to decide in advance that they want to track you. It can comb through the database of records and find out what you were doing years earlier.
They tell us it's because people are not generally sharing this information with their cell phone provider, or not at least in the general terms that we think of sharing. They also tell us that compared to a nosy neighbor, your cell phone provider has perfect memory, at least 5 years worth of data, every second on an hour. I really think that often these cases get resolved in our favor against the governments is because every single person in the United States has a cell phone, including the justices of the Supreme Court. Now that you've learned everything you need to know about Carpenter versus United States, let's look at some of the biggest misconceptions, and maybe you've missed something from my previous video. So, misconception number 1. Carpenter means police always need a warrant to get any digital data. That is not true. Carpenter versus United States focused on the cell site location records, meaning that other digital information was not covered by Carpenter versus United States. What are we talking about? We're discussing live tracking information, or security cameras, internet data, and other digital records. Those are separate. Carpenter versus United States did not discuss those records. So those may or may not be covered or protected by the Fourth Amendment. You will need to look at other cases. But again, Carpenter versus United States only focused on geolocation data, and especially historical data. Misconception number 2. It completely overturned the third-party doctrine. That is not true. It carved out an exception again for cell site location records. But third-party doctrine still applies to ordinary business records, bank statements, dialed phone numbers, etc. Misconception number 3. The government can't ever get location data now. That is not true. In Carpenter versus United States, the Supreme Court discussed whether that information was even a search. Now that we've said it was a search, it means that the government needs to have probable cause and a warrant in order to get it. So it doesn't mean they can never get that information. They just need to have a warrant prior to getting it from the phone company. Misconception number 4. Carpenter applies to private companies. That is not true. I think a lot of people always confuse what the Constitution stands for. The Constitution protects you against governmental intrusions, meaning the First Amendment, your right to speech, it is only when the government tells you to remain silent, tells you not to speak. That's when you have a claim. In your Second Amendment, it is the one with the guns. It is only when the government doesn't allow you to have a firearm that it applies. The Fourth Amendment, against unreasonable searches and seizures, it is when the government intrudes. It is when the government searches you without a warrant or takes your information without a warrant. Under Carpenter versus United States, it is when the government takes that historical data information. The Fourth Amendment does not protect you against private companies and how they use that information, meaning that your internet service provider, your phone service provider can still collect that information. They can sell that information to others and even maybe share it with the government. It is only when the government first makes the step and asks the service provider to provide the records. That's when the Fourth Amendment applies. So these are the 4 biggest misconceptions surrounding Carpenter versus United States. I hope you enjoyed this video and you're enjoying this series. I will see you in the 8th part next week. But for now, I want to thank you for watching me here on YouTube. Welcome to Lost Dash channel. If you're listening to the podcast version of this recording, please give it a thumbs up and give it 5 stars. And finally, if you want to support this channel, consider going to lostdash.com/merch or shop.lostdash.com and check out some of the merch, including these Do Not Res This Person t-shirts, hats, stickers, and other items. And because you've made it to the end of the video, if you put in the code 10cases, you'll receive 10% off. I will see you next week in part 8.